Good evening and welcome to another program of Law and Order. Now, you know, all of us, one time or the other in life, get into some kind of debt. It can be a small debt of a credit card or a housing loan, or it can be a massive billions of dollar debt in your business. But you would notice that most of the time when you're about to take the debt or when you are going to take the debt, we don't take legal advice and we are not concerned about how we are going to repay. But when the credit crunch comes, or when you're crunched by the credit and when you have to pay back the debt, we are worried and we want to check how this debt could be paid or how it could be avoided and what are the ways we can delay and how is the debt going to be recovered if we don't pay by the banks or the institution that we took the debt from. So tonight, to look into all these matters and more, we are going to tackle the topic of debt recovery with our specialist guest on the subject in the studio. And our guest is no stranger to Rupavahini. He is President's Counsel, Chandana Liyanapatabendi. Chandana Liyanapatabendi is a specialist in the law of debt recovery and other areas of law. Chandana, thank you very much for taking our invitation and coming back to Rupavahini. Yeah. And how are you today?
I'm fine. Thank you very much for inviting.
Yes. Debt recovery, like I said. Yeah. Just tell us about, before we go to the legal provisions and nitty-gritties, where did this concept come from?
No, it is actually, it's a Latin term, and Latin term now, its meaning is I owe. I-O-U.
Debt means I owe.
I owe. So then, that is actually a personal property of the creditor, where the creditor has get not only the obligation on the other part, that is a debtor to pay, it is the creditor's personal right to recover. So that with that it becomes a personal property, so that he can file an action or there are other means of recovering debts due to him from or that institution.
The age-old concept, right. Now the provisions and laws relating to, as you heard in my example of all of us get into debt one time or the other. The provisions in Sri Lanka are related to recovering these debts. Can you explain to us? I know it's a wide question.
Yeah, but actually when you say money recovery or debt recovery, first we can talk about we can mention the name of the Mediation Boards Act, then also recovering money by using the Arbitration Act or the Money Lending Ordinance, and also there are actions under the Finance Business Act, Finance Leasing Act, Finance Leasing Act, and also the normal, regular or the summary procedure given under the or introduced under the Civil Procedure Code, or also by parate execution by banks under Act number 4 of 1990, and also the topic today I believe is the debt recovery, that is the provisions which are contained in Act number 2 of 1990 as amended by Act number 9 of 1994.
Okay.
So that is the Debt Recovery Act, DR Act.
Can you take me to these provisions, how it is done and how what we have to look up to? The provisions of the debt recovery.
Actually, that has it is said that such special procedures are not available in the other jurisdictions. They say these special jurisdiction created under this Act or the procedure created under this Act was not there, is not there in the other developed countries. So this was a result of a committee chaired by Justice Vimalaratne. We call it the Vimalaratne Commission. Later on, that report was submitted to the Parliament as Session Paper 3 in 1990, I believe, and then became law. So with that, there were so many other laws were introduced for the speedy recovery of debts. That is such as Mortgage Amendment Act, in the 4 of 1990, as I mentioned earlier, and this particular act, and the certain amendments were brought into the Civil Procedure Code at that time in 1990, and that is how we got this piece of legislation.
Right. How does one, where does this act apply? Is it only applying to banks, or is it applying for any kind of debt you would take under any kind of
there may be, I will come into that later, but I think first of all it is for the institutions mentioned in the Act. That is for the institutions to recover debts due to them, due to it. So that specialized, the commercial banks under the license under the Banking Act, and then number 2, specialized banks such as specialized financial institutions such as National Savings Bank, DFCC, those are the banks. Then finance companies licensed under the Finance Leasing Act. So those are the 3 institutions. But there is a provision to say that when there is a check return under section 25 that you can bring that person into the court by a private claim, but I have different views which I will deal with when we discuss about the criminal proceedings.
Now?
Yes.
Different about the check return.
Because
now, check is a debt, right?
Because check is given to an institution, then if that institution, if it is due to that and that payment by way of a check means that is due to them, then that institution should be allowed to enforce it either under section 398 of the penal code where cheating is discussed, or under section 25 of the Debt Recovery Act.
Right.
But now there are case laws to say that the private parties also can make use of this section 25 to enforce their rights under the checks given to them which are dishonored. But my personal view is there is a dissenting judgment given by Justice Shirani Tilakwadan in a case where that's a correct law, because when you think of the purpose of the act and as to how and why it was brought in by the legislature, and especially when you think of the long title, it is only for the institutions to recover. So I would say, even though there are case laws to say, that my personal concerned view is that private persons cannot or should not be allowed to use that provision section 25 of the debt recovery law to enforce check return cases.
Okay, let me take a practical example before we go to the other provisions. I know we have a lot to talk about, but see, a lot of people take a loan and give a check post-dated. People are that is a habit in Sri Lanka. So what you are saying, in a situation like that, if it's an individual, he's trying to enforce that, and there are judgments which allows that, or judgments which says it cannot be done.
No, that there are two judgments to say that can be, it should be, that rest of the parts of the act is taken, should be taken separately, and this section 25 should be taken separately. But when you think of the, I personally believe that when you think of the purpose of the act or the piece of legislation, and as well as when you are considering the long title, it is not for the private individual, it is only for the institutions.
Which allows people. Those are Supreme Court judgments.
But there is a
contradictory judgment.
No, there is a judgment by 3 judges in which Justice Shirani Tilakwadan has dissented.
But others who have said they can. So at the moment, because of that Supreme Court judgment, people can use section 25 of the Debt Recovery Act and go and dishonored check can be cleared. Not cleared, go to court.
Chanakya, that is the case law says, but my personal view is
your personal view. Yes. But is that it shouldn't be. That is because the act's purpose was different.
Right?
Now, before we go to the provisions, if that is the case, has Sri Lanka law provides in any other area where a check is dishonored, that person to recover that on a civil, as a civil claim?
Civil claim is a normal money recovery action under the Civil Procedure Code, or otherwise as an exhibit you can file a normal regular action, or summary procedures specially provided in the chapter called Summary Procedure on Liquid Claims. So that's another area where you can easily.
Why do those people go to use that section? Is it faster to use the Debt Recovery Act?
Yes, because when you are brought before a magistrate court and your personal freedom is at stake, and then you will sometimes the money will have to be paid in to get the bail even. So that is not the purpose of that act.
Right, but don't you think, given so many instances are there, we are still harping on this example of check, that it should be amended to include situations where people's checks are dishonored, individuals. I'm not talking the listed institutions, individuals' checks which are dishonored could be recovered using this process. Shouldn't it be amended? I know you disagree because your opinion is that the personal act is not meant for the moment
even
like
though
that,
the two case laws are there, I think it's a duty of the legislature to amend and make it clear. Once and for all.
Right. Now, what is the procedure of a bank or an institution who will say, I owe the bank, of using the procedure of debt recovery law and filing action? Take me through the procedure.
It's very simple, because bank only have to decide that there is a debt due to them, and then they have to file a plaint, but together with the plaint they have to give an affidavit of a principal officer of the bank saying that particular amount is rightly due or justly due, that the present law as after the amendment is rightly due, rightfully due. So that we get together with that, there should be a decree nisi, draft decree nisi, and then stamps adequate for that decree nisi, and then also copies of that instrument under which the action is brought in, like the check or the promissory note or the agreement, that has to be there, and the original will have to be deposited with the court. And then the court, what the court does is, they go through the sufficiency of the or requirements of the law, and see if it is satisfied that there is a action, there is a prima facie action or has been established. Under those circumstances, they issue order nisi and ask the defendant to come before the court and show cause. They are not permitted to file an answer like a normal regular action. He must first of all show that he has sufficient cause to show regarding the claim or regarding the instrument, like that he must make a defense. He cannot just say that I owe nothing. So then that is how then it goes back to the civil procedure code again for the trial of those issues. But before that, but then there is another thing involved, that is the court will have to go through that defense and consider whether there is a triable issue. If not, the party will have to either, if they are agreeing to deposit the money and fight the case or argue the case, yes, that is permitted. That is under section 6(1). Otherwise, court satisfies that there is a prima facie case and there is no particular defense. Court will have to ask them to deposit a security, make security sufficient to pay the decree nisi if it is made absolute. The third situation is where the court finds that there is a prima facie case that they have set, there is a defense that they have taken up. Under those circumstances, but still sufficient security should be there. There should be a security. So security is the main thing that the court will have to consider in allowing the other party to.
Security, is it the total amount of debt?
No, that is the total amount of debt which is there in the plaint. That is the first instance where the party will have to deposit into the account and court and argue the case. They are ready to meet the case.
Total amount of debt.
Yes, then that is that's the easiest way if you have the money.
So if you have the money, why do you want to?
No, because you still have there's a stringent procedures are there. So better if they have money and if they have a good case, they can deposit but that is not going into the plaintiff's hand. It is there in the account of the court, but they have the right to then fight the case. Otherwise, they have to show a sufficient cause in their application affidavit. They have to say that by giving a proper defense. The only other situation is where the court satisfied there is some defense. So under those circumstances, court says yes, we will try that issue. Here are the issues. Let's agree on and then court orders some kind of security.
Some area, I may repeat my question. Some area my public might not be clear. Is that okay? I have 100 million. The bank is filing against me. Then I have 100 million. I have to deposit the entire 100 million and do a defense.
That is on the first instance. If you want to, without showing any cause.
Right.
Then secondly, you file the application and say that I have something to argue. I have something defense.
Yes.
So that is the second situation. Third situation is where the judge satisfied that there is a prima facie defense.
Yes.
So that's the third situation.
Right. What is the appellate level from there?
No, actually that's a Special Procedure Act.
Right.
It has not given any right of appeal.
Really?
It has only given the thing called leave to appeal. So that again.
Leave to appeal to which court?
To the higher forum, that is earlier to the Court of Appeal, but now with the introduction of the civil appellate high courts of the provinces, you have to go before that, but again you have to ask for the leave to appeal. So again you have to show that there was a tribal issue, there was a question of law which had been disregarded, like that. It is not easy. Again, you will have to face certain consequences.
Appeal is available to civil
from there
to the Supreme
from there to the Supreme Court, but again, you have to
why are you
leave to
the
appeal.
fact that it is very stringent in this appeal process?
Because
is it different to another leave to appeal?
Certainly, because if you consider normal district court action, the party has the right to appeal because the rights are given in the appeal and the constitution also. But here this is a Special Procedure Act, given a lot of chances for the defendant to come and meet the claim of the plaintiff. If not, it's not easy just to appeal. You can't just file an appeal and wait. It also says that you once the appeal, just because the appeal is lodged, the procedure into the lower court is not stayed unless otherwise the court directs, which means when the decree is made absolute, it works like a execution of the decree. So then, under those circumstances, it is not stayed. So that even though your application is pending in the civil appellate high court, you have no chance. The writ can be executed by the registrar, because that is a order to the registrar to execute unless the court otherwise direct to stop.
Right. Now, this law came into special provision number 2 of 1990. In 1990 this came.
Yeah.
Why was this necessary?
Yes, I don't know. As I said earlier, there was a big argument among the complaint about the industry, saying that the normal procedure given in the civil procedure code or the check is not that easy. It takes months and months for the other party to file to serve summons or to file answer. Then after filing the answer, the list of witnesses and things like that, and when it comes to trial, then there are dates being taken for various reasons. So for that, since what they said was, we have a document, we have an agreement with you, and on which we have lent some money, you are supposed to pay. If you don't pay, why do I have to go on a lengthy procedure? So that was the matter considered by this Justice Vimaratna's commission at that time, when they were appointed to look into these laws, and this is how it has come into being.
Right. Now, you said the list of institutions that are mentioned in this, which is financial institutions and licensed commercial banks and so on and so forth. Now, are there types of action, types of loans can only be recovered through this, or any type of loan given by the bank, including personal loans and car loans and leases?
Actually, the Act.
Yeah.
The Act says in section 30, which is the interpretation clause, it means a debt.
Debt. Any debt.
It doesn't mean, that means there was argument taken once that overdraft facility is not a debt. Yeah. But there is a section to say which is rushing out of a banking transaction or such thing. So then that was overruled. So that means if anything comes under the meaning of debt, therefore is recoverable under using this.
Including
so
overdraft.
Overdraft, credit card facilities, even like that.
In your experience, I know you practice in this area a lot, among other things. How has been the successful rate of this exercising powers under this piece of legislation by the banks?
One thing I must say,
has it cleared the backlog of recovery?
Certainly, because that was very fast-track procedure, and the date inserted in the summons is only considering the distance from the residence of the defendant to the court. That's all.
What does that mean?
It means it doesn't consider about giving long dates even to come before the court to file their application for defense. It's very stringent, but it does not mean that they are not given any chance. But the thing is, here under this law, you cannot file a proxy and ask for a date to file your answer. Here, the first day itself, you have to be ready. The defendant will have to be ready with his proxy, appointing an attorney, plus his defense. So that is, I think, and there is a special trial role also to be kept under the Act. So with that, every district court is maintaining this DR register, debt recovery register. I think I don't have the figures with me at the moment.
But very successful.
Very successful because it is not allowed to file answer. With that provision, people are bringing the money or coming to some agreements.
Okay.
To
now,
pay.
how does this procedure differ from other procedures which are available in the civil procedure code? The special procedures in civil procedure code and the jurisdiction issue, who can institute execution of decrees, all that. How does this differ from other recovery procedures?
One is the procedure, that is under civil procedure code, there is a plaint and answer involved and a trial of issues later. and then, but here under this, the application is by way of a plaint by the institution, and then other party has to make an application to by showing some defense. So answer is out under those circumstances. Number two is when you think of the jurisdiction. Normal law says because of the creation of the Commercial High Court, which is under the new act, then particular after if the amount exceeding 5 million must go to that court under civil procedure court. But here any debt recoverable by an institution given under the act has to come before the district court of the area. So that is other one is a procedure later on. So straight away the decree nisi is entered and it is served. So it is, if there is no defense, only it has to be made absolute. And also there is another thing, no appeal, no right of appeal. Yeah, I mentioned that.
Yeah.
So those are the things.
So the traditional objections cannot be taken. One last question. You've seen people getting into the problem, and it's very difficult to get out once they file. What are the reasons you saw people getting into debt problems with banks and these institutions in Sri Lanka, and not being able to pay, and the banks has to execute, invoke a debt
because
law?
Every bank usually,
this is beyond
certainly. Every bank usually takes something called security, some sort of a security other than in a credit card. But again, in a credit card, your income levels has to be. But the thing is, it's our country. I think the main problem is we are not in mind. Our mindset is not keeping in. We don't keep in our mind that we have to one day pay this loan every month, or as agreed. Right. What we do is we allow that to be. We disregard the fact that there is something called CRIB, Credit Information Bureau. We tend to delay without getting into this problem. I think the people will have to have there in their mind when they take it, because there are stringent procedures are there now. Your personal liberty is at stake. Then number two, your property will be sold or in auction or will be executed under this. So you have to consider that and have your mindset ready when you take a loan, because without taking credit, it says the bank creates money.
Yes.
It is by taking credit only you prosper, you have your housing loan and you make your business successful. But you must also make sure that it has to be paid back as agreed.
Yeah. This change of lack of change of this mindset is what has caused people to get into a lot of debt.
Certainly.
Right. Chandalina Prabhu, the President's Council, thank you very much for joining us today, and thank you for those very valuable thoughts on a topic we have not touched before, and thanks for your input.
Thank you very much.
Thank you again for coming for Law and Order.
Thank
That's Law and Order for you today. We'll join you next week at the same time on Law and Order. In the meantime, you can join our conversation on the Facebook. Go to Facebook/Law and Order Channel I, Facebook/Law and Order Channel I, and join the conversation. You can post any questions that we could take up or message us on that, and go to our Channel I website and check for Law and Order and watch the shows all over again. The past shows you can watch on that. Have a good night and a good weekend, and enjoy the rest of the programming on Channel I.